See, okay, got it. All right, all right. So Ms. Salazar, you were placed on probation. I'm sorry, you were placed on a deferred, right? It's a deferred, right?
That's right.
You were placed on deferred for assault of a family member. You need to understand something very, very serious is happening now, where you were pleading true to the fact that you have since violated this probation by picking up the felony injury to an elderly. You need to understand that this will now go on your record. It will now reflect as a conviction on your record, and there's an affirmative finding of family violence. What that means is that if you ever pick up another assault of a family member, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be a drag-down fight brawl where you're punching. No, you just grab someone's arm and squeeze enough to where it hurts. You were looking at up to 10 years in prison. There's one irrefutable fact here is that it's 1, 2, 3, 4, 5 different assaults. 90% of the people that are in jail because they have no self-control. They get upset, they wig out without think before you act. You have children, right?
Yes, too.
Who suffers the most while you're in there?
My children.
That's what you need to think about. If I get upset, who's going to suffer? So is it true or untrue that you violated your probation, ma'am?
True.
All right, I'm going to find that it's true. I'm going to reform the judgment to reflect as a conviction now. I will sentence you to 140 days in jail. I will give you credit for the 49 days that you've done. There is an affirmative finding of family violence. All right, ma'am, we wish you the best of luck.
Thank you.
Self-control.
Yes, ma'am.
Good luck. Thanks, Mr. Mendes. Oh, yeah, I haven't seen her in a long time. Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful being on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
Like that.
Yeah.
Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then.
Right, but then cops get up there.
And then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge.
behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's an some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating, a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only.
right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and
He leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them.
Yeah.
All right, man. Good luck.
Thank you.
Unless you.
You were Mr. Duger.
Yes, sir.
Mr. Duger, you're charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 60 days in jail with credit for the 20 that you've done. You need to understand that this charge will go on your records. Isn't that right?
This will be 3 for 1 credit, so this will be times.
Shh. Yes. Yeah. I mean, from what I understand, it's 3 for 1. So yeah. Right. But the bigger thing is this now makes at least 2 thefts for you. You pick up another theft, you could be potentially facing a felony charge where you're looking at years instead of days.
Yes, sir.
Do you understand?
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off.
Yes, sir.
This is what you want to do.
Yes, sir.
How do you plead to the offense? Are guilty or not guilty? I'm going to find you guilty. I will follow the agreement. It says here that you have a prior assault from 2020. Is that true that you had that? Well, no, you got to. Yeah. Is that true that you had the prior assault, sir?
Yes, sir.
All right. True to the enhancement. All right, sir. Good luck.
Thank you, sir.
Thank you. Mr. Clackett, what's up, man? Hey,
I have two, Judge. First name is, or sorry, first case is Franklin.
Page 9 and 10.
Thank you.
Here.
it's not, oh,
So on bond for terroristic threat, picked up a criminal mischief. The criminal mischief,
now?
he is here. And the criminal mischief is that he supposedly broke a window inside of an apartment.
We have to do PC, I don't know.
Yes, Judge.
Don Franklin, come up.
Go around for. I'm going to add the word supposedly and allegedly, like salt and pepper in this case, because nobody saw it happen.
Well, we still have, yeah, give me a second.
Yes, sir. No, sir. Okay.
Hold on.
Does he, hold on. That's going to be the creepy grandpa and offer candy, but all I've got is peppermints. So arms by your side, stay calm, don't talk, okay? All right.
Council for reset? Oh.
Here, love.
Oh, and then.
Yeah.
All right.
Okay. Appreciate it. Thank you.
Mr. Ladon, you are on bond for a terroristic threat. You've now picked up a criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas. Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate, accusing him of breaking a window at her apartment.
Whoa, hold, you're going really fast.
Yes, Judge.
The defendant,
Called the officer.
okay,
And he said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment and that the complainant came out the back door to her apartment, but then he changed the story saying that she came out the front door to of her apartment to confront him. The complainant stated that the defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
the only thing, my concern is who broke the window? Did he break the window?
Thank you, Your Honor. So according to the DMs, what the complainant said is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. And she repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they,
We have the two further just complaints said that he was approximately 20 feet away from the back door when she saw him and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know, it's,
To be honest, just what we have is that the window was broken and then she saw him outside at the time when she came downstairs to check on. That's what we have.
I get it. I
Yes,
get it.
Judge.
I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Acid fees be waived. Okay. I'll add.
How far do they
Judge-
live from each other, Alex? You know?
Do you have the
So-
same complex?
It was described as across the street. But when I spoke to the complainant, she said that
That's not
they do
what
not
he
live across the street, that he was staying at a friend's house. But he told officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if in fact you can prove that he has a weapon.
Yeah, Judge.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You were ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses,
Yes, Judge.
get a hold of the cop.
Yes.
Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask, Judge, that we reset for more than Monday, only because this case is new enough that there's literally no offense report. So I don't know officers' names or.
Case.
So the new case, the criminal mischief, which will be the allegation for the motion.
Find no probable cause in the criminal mischief.
Well, but the problem is, Your Honor, is that it's on the criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So that way they can review it and
So the allegation is, and it's we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both have saw a knife. And so
Well,
that's why.
I don't know
So,
if
I
anybody
mean,
is.
I guess I'll give you a full week. You know, that should be sufficient for you to get an
Yes.
OR,
Yes,
get
sir.
in contact with
Because-
both witnesses.
Just to clarify for both parties here, the officer is the one that said when he contacted him, he's found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it. So that in today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.
All right,
Do you have to
see you in a week.
I'm going to talk to you in a moment.
Whatever he's
We're
done.
finding no issue on the criminal mischief.
Yeah.
And I had a question. I'm sorry to interrupt, but earlier when we had Mr. Sims here.
Days with these step by checks.
Yes, Judge, registration.
All right, let's say you're free to go. It's highlighted for you. Because I forget to check out. I'm moving to better. It's Mackenzie's. I'm sure.
Okay. Yeah, cases. The evidence was or her statement. Right.
Yeah.
Pills. I guess it's Adderall.
Right.
And, like next to her, and then he keeps on. But you know, she's got this 2 people and stuff, so he puts her in custody. And, he, asked her, whatever the thing that's she makes. About that, it's my model. Last my wondering, while she's asking, but how do you know? Then you go to your back and look at those forward. And, you see how she thinks she doesn't. Doesn't feel like big, so just, I had been told her.
Sure, I've seen that's about.
Oh, okay, all right, so, did you guys, do you want to do it? The felony is going to be discussed, so she's got a few more conditions to finish.
Right, I see the conditions for the validity. For PTI.
Yeah, that's it.
Well.
I mean, technically. Yeah. Or actually, even sort of saying that like ownership of the gun, it's just like, you wouldn't be able to get one of these. The gun would be legal without it. So.
You can choose to be managed like this.
The drugs. It's like, she was.
I don't know, that doesn't look like a chicken to me. Putting another lollipop in the cake.
The gun actually was.
Yeah. Hey, now a candy cane on the cake. That looks gross.
All right, you're saying.
Ooh, that's too much. You want to try it again? Now look, you can put other things like you can put candles on it too.
Yeah, it's like that. Have it in a cube too. It's also not. Ramirez Luis. Oh, okay, yeah. Okay, Brad.
I choose black. I did it again.
I see. Hmm.
Wow.
Whisper. Oh, we have a ton of trials for next week, huh?
I know.
Ton of trials.
Talk about she used to with me. About it. But I don't. It is also the more time for them than 1 years old. I don't want to hold on to it longer than we have to. Jump around. I was more 19.
Yellow cake. Yellow.
That looks good. That looks good. That's what a cake looks like. What? No, hit the X right there. There you go. Choose different, like, you can put over here to choose something different. See, you go down. Those are other things that you can put on the cake. Hey, Alex, we have a ton of trials for next week. Do you know you're ready to go on and who you're not?
Cool, the trial document, quick judging, let you know.
Like maybe 1, 2, 3, 4, 5, 6, 7.
Why's not going?
Yeah, pick one and then move it. I see that you guys filed a motion for continuance.
Yes, we filed on one of the cases.
Have you talked to the defense lawyers, see their position?
Okay.
I don't know. She talked to the defense about the continuance.
Your Honor, I sent an email. I haven't heard back from them. My goal was to get them to approach the
As far as the, with Jillian, you mean?
Yes.
Okay.
I haven't heard back from her. I asked her if she could come in one day this week to approach. But her issue is that a witness isn't available.
You get one continuance. That's it.
Yes, Your Honor.
So you get one crack. That's it. So
Yeah,
if
It's
they come back and.
notoriously hard to track down and get in court, so I was.
Okay, but like I said, like if you get a
Yes, and
on
I
a
did.
date and then,
Being ex parte, Your Honor, I did, when I called them, I made sure that the next day,
okay.
we did get good dates for them, so.
Got it. Okay, yeah, so let's just, I guess I'll wait for Jillian and we'll see what her reply is and then Go from there.
Thank you.
Are you guys ready on everything else then? All the other trial cases, you ready?
Working on them. I just got this for yesterday.
Yeah. Okay. Take your time. No rush. Yeah.
Your Honor, also looking at those cases.
Hey, ready? Yeah, come on up. How are you?
How you doing?
Co-counsel's just, he doesn't listen. Other than that, great. How are you?
What, we're approaching on Torres, Your Honor, Christopher Torres.
Okay. Okay. What are we doing?
Well, this is where we're at is, I don't know what your position is on approaching without an agreed rec. That's why I'm approaching.
Okay.
Or how you work that, or do you do that?
Yes,
Yeah.
yes, but not, no, I'm gonna time serve on a second.
So
So,
to give you some background, my client has a prior intoxication assault that he had a probation for. Yeah, in 2013. So he's completed that. And so this is filed as a DWI second. It's a 1-6. It was an accident.
the intoxication assault was the first.
I don't think he has any other criminal history, does he?
Not, double check. A class C public intoxicant 2010, but nothing
In
else.
2010? Yeah.
Okay.
So this involved an accident, and the RIP call says there was just some damage and they just wanted to be paid for that. I submitted an insurance document to the state that showed that he had insurance and they were paying. And the thing in the RIP call, the guy says he hasn't been out of pocket. And anyway, so the state.
Oh, not even, no deductible or anything like that?
So,
No.
and that's what the complainant stated that the insurance was supposed to be taking care of it. I don't have the information on the deductible. I can get that.
I want to make sure that, I mean, before we do anything, I want to make sure that this person is made whole.
Of course.
I don't want to,
And I'm all right with the reset too, Judge. I'm not.
or, you know,
We talked to them on 2/3,
Yes.
and I can follow up today just to see what kind of out of pocket are we looking at? Did insurance take care of it? Which I would agree, they're probably the deductible.
you know, my concern is that we have a prior intox assault and now we have another one. So he's just not getting it. So how do we do that? We need to monitor him for a while to make sure that he understands what's going on and perhaps fix any issues that need to be, you know, potentially fixed. So I would say if he wants to do anything, you know, like do a TRAS, let's set him up for a TRAS and see what it says.
Okay.
That's what I'd like to do. So, yeah, let's set him up for a TRAS because I don't, you know, it's concerning the intox
Yes,
assault
I
and all
understand.
this. Let's see what a TRAS says and then we can go from there.
Okay, thank you, Your Honor.
Really like to follow the advice because those people usually really nail it on the head as to what we should do.
Okay, thank you, Judge.
Thank you, Aaron.
So let's set it out. Is he here now?
Yeah.
You want to send him now since he's here? We could do a walkthrough and then we can reset it like 2.5 weeks to get results. And then in the interim, that gives him time to work on the restitution. You okay with that?
Yeah.
All right. Money.
Yeah.
Did you need me? I can try. A lot of times they
I'll move to do this. How am I gonna get on this?
Because she basically, okay, so, but I understand, it's a CPS. Well, no, also says no. So.
Yes. By the time you get her.